A dispatch from Kensington Palace pushes to the devices of every royal correspondent in Britain and most of them in North America. The welfare of Archie and Lilibet is non-negotiable. Any attempt to remove them from their lawful jurisdictions will be met with the full weight of constitutional remedy. The words are attributed to a spokesperson for Prince William. They are clearly his. They carry the specific quality of language that has been chosen very carefully by someone who is angry and is controlling the anger through the mechanism of precision. Every word, load-bearing, nothing decorative. The whole sentence, a warning delivered in the register of a formal instrument rather than a family dispute. The statement confirms what overnight leaks had been suggesting for hours. A covert relocation plan, designated internally as Project Mirror, had matured from rumor into something that was no longer hypothetical. But the phrase that stopped everyone reading it, the phrase that was screenshot and quoted and discussed on every platform that covers the royal family before 8 o'clock that morning, was not the warning itself. It was the explanation that followed. Prince William acted at the request of his brother. Nobody had expected to read those words. Nobody who understood the history between the two brothers, the years of estrangement, the Sandringham split, the public grievances, and the private silences had thought it was possible at this specific moment in the story for William to be acting at Harry's request. And yet, there it was, in an official palace communication, documented and unambiguous. To understand why it was there, you have to go back to a phone call that happened on a January evening. An encrypted line connecting a man in California who had just received information that had dismantled his understanding of the situation he was living in, and a man in Windsor who was the last person he wanted to call, and the only person with enough institutional authority to do what needed to be done. Between those two men on that call, the shape of what would eventually become Project Mirror's undoing was established. And what was said on that call, and why Harry made it, and what William chose to do when he answered, is the real story behind the palace statement that woke up the British media on that February morning. This is the story of Project Mirror, a covert relocation plan that, had it succeeded, would have placed 2 children in a Qatari household on tourist visas while their residency applications processed over 4 to 6 months in a jurisdiction outside the Hague Abduction Convention under a guardianship arrangement that carried their mother's signature and nobody else's. It is the story of a financial freeze executed across 3 banking institutions in under 6 seconds. A sealed affidavit transmitted to a California court at 2 in the morning. An 8-hour hearing in which a money trail did what legal argument could not. A handwritten declaration renouncing a dukedom. A judge's sentence that historians will quote for decades. A viral video filmed in a playroom. And 2 children's passports sitting in a climate-controlled safe in a courthouse clerk's wing, the judge's seal glinting under fluorescent light, waiting for the adults in the story to decide what comes next. Behind it all, behind the court filings and the financial instruments and the institutional machinery, was a simpler and more human story. A father who discovered a plan to move his children to a country he had no legal standing in, and who understood that he had one phone call to make. Not to his lawyer, not to his publicist, to his brother. The discovery came through Doria Ragland. Late on a January evening, Meghan's mother found flight itineraries and notarized guardianship drafts in her daughter's handbag documents, whose contents, when she understood what she was reading, prompted her to leave a voicemail that Harry would later describe to a friend as the most frightening message he had ever received. The children were to fly Los Angeles to Doha on tourist visas. They would then be lodged with a Qatari host family, sourced through an entity called Pearl Guardian LLC, until long-term residency permits could be secured through the appropriate Qatari government channels. Harry had not seen the paperwork. He had not been consulted about the plan. A friend recalls his description of the moment he understood what the documents meant. It felt as if the ground had opened and swallowed his lungs. His legal counsel's assessment was immediate and sobering. A unilateral injunction, filed without institutional support, might arrive too late. If the aircraft left Los Angeles before a restraining order could be stamped by a judge, jurisdiction would shift to whatever territory the children were in at the moment the order issued. Once they were in Doha, enforcing a California or British court order against a Qatari household arrangement would take months at minimum and might prove effectively impossible. Harry needed something faster and more powerful than a personal legal filing. He needed institutional muscle, and the institution he needed was the one he had spent the previous years publicly and repeatedly criticizing. The phone call happened on the evening of January 19th. Harry dialed the encrypted palace line, the one he had last used during the Sandringham discussions of 2020. William answered. The call lasted 43 minutes. People with knowledge of its content say Harry did not ask for sympathy or reconciliation or the reopening of any of the family conversations that had been suspended since the departure. He asked for specific, targeted, institutional intervention. He described the plan he had discovered. He explained the timeline. He laid out why a California filing alone would not be sufficient. And then he waited. Two things moved William. The first was Catherine's quiet observation, made when he described the situation to her that same evening. If a frightened father cannot lean on his own brother, what hope do their children have when they are grown? The second was something more visceral and more personal, the specific image of Archie, 10 years old, pacing an unfamiliar tarmac in a country whose language he did not speak, without either parent nearby. That image, William would later tell a close aide, landed like ice water. Within 48 hours, he had convened the Royal Household Finance Office under Emergency Protocol VX4. Project Mirror's structure, as William's team assembled it from 3 separate intelligence channels, was more sophisticated than a simple relocation plan. Aviation manifests from charter brokers showed 5 pseudo-anonymous bookings to Hamad International Airport between October and December of the previous year, reconnaissance trips to establish logistics and contacts. Financial monitoring had flagged atypical transfers from an entity called Echelon Limited, routed through a Doha shell company called Sandpillar Media, in amounts and patterns inconsistent with ordinary commercial activity. And a junior archivist at Archwell, acting on conscience rather than instruction, had forwarded a 42-page blueprint dated January 18th, the operational document that gave the plan its name and laid out its mechanics in the specific, procedural language of something that had been prepared by professionals. The Doha route had been chosen with a care that was visible in every logistical detail: the choice of Pearl Guardian LLC as the brokerage firm, the selection of the Al-Khamzi household as a caretaker family with the specific profile of wealth and international experience that would make the arrangement credible, the enrollment inquiry submitted to Luca Academy months before any public indication of the plan existed. But it carried fatal structural flaws that its architects had apparently not fully examined, or had examined and concluded were manageable, or had concluded were acceptable risks in the context of a plan whose primary value was speed. Qatari tourist visas for US and UK nationals cap at 90 days total, extendable twice, for a maximum of 90 days combined across all extensions. Children on tourist status are ineligible for Qatar's public health insurance until a residency permit number is issued. Under Article 14 of the Private School Statute, tourist children cannot register for grade-bearing coursework, meaning any attendance at Luca Academy, the institution Pearl Guardian had provisionally enrolled them in, would expose the academy to regulatory fines and expose the children to potential deportation. And, most dangerously, after 90 consecutive days of presence, Qatari family court judges could recognize habitual residency, handing any future custody dispute to the Doha Circuit Court system entirely outside the UK-US treaty framework that had previously governed the children's legal situation. The plan Meghan had authorized did not simply risk moving the children to another country. It risked losing legal control of their future to a jurisdiction that neither parent had anticipated and that neither would be able to navigate easily. The sealed directive left the finance wing of Kensington Palace at 6:30 inches the morning. It crossed 3 continents in under 6 seconds. Accounts at Coutts, HSBC, and Lloyd's connected to Sussex-linked entities were frozen. A £7.8 million sustainability fund was locked. 24 trademarks, Sussex Royal, Archwell Audio, Lilibet Books were swept into emergency escrow pending review. The message to Meghan's financial infrastructure was not ambiguous. Money powering Project Mirror would stop flowing at the source. In the small print of the freeze order, auditors found the bridge loan that transformed the financial intervention from a precautionary measure into documented evidence of intent. £1.1 million had traveled from Sandpillar Media in Doha through Echelon Limited in the Cayman Islands to Tide Haven Holdings in the British Virgin Islands. The loan contract's memo field referenced Phase 2 content activation pending residency confirmation. This was not a speculative entry in a creative business plan. It was a contract, signed and countersigned, that described the financial architecture of a relocation that the publicly stated position of all parties had been to deny was underway. William now held the map, the money trail, and the timetable. The palace statement, released at 6 o'clock the following morning, was the first public flex of that arsenal. The breadth of the freeze order went beyond the accounts directly connected to Project Mirror. It swept up the shared intellectual property that the Sussex enterprise had spent years assembling, the trademark portfolio that was the foundation of the brand's commercial value, the savings instruments that provided the operational buffer for a household with significant security and staffing costs, the property interest in the Gloucester estate that had served as a potential fallback asset. William had not simply cut the funding line for one plan. He had restructured the entire financial architecture of the Sussex commercial operation to ensure that any successor plan would face the same structural obstacles. Sources present at Adelaide Cottage the night the freeze orders were signed described Harry as color-drained, hands clenched, blinking in the way of someone who has absorbed information that keeps landing in new configurations every time he processes it. He thanked his brother in a voice that the aide present described as barely audible. Then he added something that the aide remembers with the specificity of someone who understood they were watching a genuinely significant moment. "I never wanted it to be you against her." The contradiction in that sentence, the acknowledgement of what he had asked William to do, and the grief of having asked it, captures the specific quality of Harry's situation. He had saved his children by initiating a legal and financial assault on their mother. He was proud of it and broken by it simultaneously. Those two states had not resolved themselves and showed no signs of doing so. Harry's attorneys filed the ex parte application at Santa Barbara Family Court on February 14th. The application sought a temporary emergency restraining order preventing Archie and Lilibet from leaving United States or United Kingdom territory without both parents' consent. The filing leaned heavily on the disclosures William's office had decrypted in the preceding days: the flight manifests, the school enrollment drafts referencing an expected arrival date in late February, and the Pearl Guardian Family Integration Pack naming the Al-Khamzi family of Doha as caretakers of first resort until a Qatari residency permit could be issued. Judge Maya Caldwell scheduled an emergency session for 8 o'clock the following morning and ordered Meghan's legal team to appear with the children's passports in hand. The Gulfstream slot to Doha was booked for 7:05 a.m. Pacific on February 17th, roughly 48 hours after the next scheduled status hearing. If the aircraft left before a restraining order could be issued, jurisdictional control would shift to whatever territory the children reached first, and enforcement of any subsequent court order would become a multi-month international legal exercise. William understood this window and moved to close it through a second channel operating simultaneously with the California filing. At 2 a.m. on February 15th, his private secretary transmitted a sealed brief to Judge Caldwell's court. The brief was an affidavit under the Windsor, California Reciprocal Accord, a trans-jurisdictional instrument that declared Archie and Lilibet sovereign minors under provisional crown guardianship for the purposes of the proceedings. Under Section B of the Accord, any prospective permanent relocation had to respect a requirement that the destination jurisdiction maintain extradition parity on child custody rulings. Qatar, as a non-signatory to the Hague Abduction Convention, fell clearly outside the safe list. Judge Caldwell accepted the affidavit as what she described on the record as a trans-jurisdictional anchor, a piece of documentation that gave the California court authority it might otherwise have struggled to assert over an international movement. The hearing lasted 8 hours. Meghan's legal team argued that Project Mirror was exploratory brand planning, that tourists were free to travel, that no binding contracts had been executed. The money trail demolished each element of that argument in sequence. A forensic accountant named Caleb Ortiz stepped forward and projected a 3-line timeline that the courtroom absorbed in silence. 1.1 million credited from Sandpillar Media on January 3rd, £480,000 spent on designer wardrobe items 2 days later, £670,000 paid to Palm Aviation for a private jet retainer on January 12th. 32% of those costs, he testified, had been disguised inside Archwell's education outreach ledger. Then came the document that the proceedings would be remembered for. The Pro-Guardian Family Integration Pack, authenticated under the discovery rules of the California Family Code. It appointed the Alcomzi household as caretakers of first resort for Archie and Lilibet until a Qatari residency permit could be issued, a period estimated at 6 months. It carried Meghan's full electronic signature. It carried no signature from the children's father. Judge Caldwell asked only one question. Did Mr. Mountbatten Windsor countersign? The softly spoken no cracked the room like ice. The afternoon session of the hearing, after the Pearl Guardian document had been entered into evidence and Judge Caldwell had asked her single devastating question and received her single devastating answer, had a different quality from the morning. The morning had been about competing legal arguments and financial documentation and the specific procedural theater of adversarial litigation. The afternoon was about something quieter and harder to manage, the human reality of what the documents described. A father learning in a public courtroom what had been planned for his children while he was unaware. A mother sitting across the room from him, having heard her electronic signature on a document that appointed strangers as her children's caretakers read into the public record. A judge presiding over a proceeding that had stopped being primarily about jurisdiction hours ago and had become primarily about what it means to be a parent. Harry had been seated behind his lawyers for the duration of the hearing, pale, restless. Observers noted him repeatedly mouthing a question that nobody near him could hear clearly, but that those who knew him well could read from his lips without difficulty. Why didn't she tell me? He had read the guardianship deed during the lunch recess. He had seen the Alcomzi terms. He had seen his children's names in the document, their ages, their educational profiles, their photographs included as appendices to the family integration pack. He had seen, in the specific and bureaucratic language of a legal services retainer, the configuration of a future that had been designed without him. His emotional state, which had been visibly controlled through the morning session, became something different when the Pearl Guardian terms were read into the record in open court. He whispered something to the aide seated beside him that was overheard by 2 press pool observers and subsequently confirmed by Harry's own legal team. They would have woken up without either parent. The aide placed a hand briefly on his arm. He sat motionless for a moment. Then, at 2:23 inches the afternoon, he rose from his seat, walked to the clerk's table, and submitted what was logged as Exhibit H12, a handwritten document on palace notepaper, a declaration renouncing the style Duke of Sussex. The last line of the document, read into the record by the court clerk, was 9 words. Henceforth, I answer only as father. The color drained from Meghan's face in a way that the press pool photographs captured without ambiguity. She did not speak. Her lead attorney leaned toward her ear, but whatever was said did not produce a visible response. Judge Caldwell recessed for 90 minutes, then returned to deliver a ruling whose scale reflected the scale of what the evidence had established. A permanent injunction barring either parent from relocating the children beyond United States or United Kingdom borders without dual consent and a $5 million bond. Mandatory repayment of $1.3 million taken from philanthropic funds. A full forensic audit of Archwell's accounts. A 10-year commercial ban on trading in the words Arch, Windsor, Sussex, or Lily in any jurisdiction. Control of the children's social media presence transferred to the Royal Child Welfare Trust. And a closing sentence that every outlet covering the proceedings published in full: motherhood cannot serve simultaneously as shield and saber. The High Court in London mirrored Caldwell's injunction within the hour of its issuance. The legal wall that William had described to Harry as the necessary objective, a structure enforceable on 2 continents simultaneously, leaving no jurisdictional gap through which an aircraft might pass before a court order could be served, was now in place. Princess Anne activated the Custodial Advisory Committee. Duchess Sophie accepted co-guardian status for any future UK visit. Lady Louise Windsor booked a welfare flight to California within the terms of the Windsor-California Accord to conduct a welfare check on Archie and Lilibet. The commercial infrastructure of Project Mirror dissolved within hours. Sandpillar Media in Doha canceled its content grant. Palm Aviation blacklisted the Sussex client code across its global reservation systems. Pearl Guardian LLC scrubbed its website, the Family Integration Pack, the Al-Khamzi Households Profile, the Luca Academy enrollment documents, all of it gone from the public-facing version of the company's services. Archwell's board, reeling from the volume of resignations that began arriving in the hours following the ruling, voted to initiate wind-up proceedings. The foundation that had been the financial and institutional center of the Sussex post-royal enterprise would be dissolved. Global brand tracking firms cut Meghan's licensing score from 52 to 28 in a single trading session. A movement of that magnitude in speed and brand valuation metrics is the specific signal that institutional investors send when they have decided that a partnership has become a liability. On the evening of February 20th, William and Harry walked the East Terrace behind Windsor Castle. A distant telephoto lens caught 2 silhouettes in the fading winter light, not close enough for the photographer to hear anything, close enough to confirm that the walk was happening. A palace aide who was present at the far end of the terrace when the brothers returned reported 2 sentences. William's, "I will always open the gate if you knock." Harry's reply, "Thank you for not closing it first." They were not healed. Nobody who knew them was pretending they were healed. But for the first time since the Sandringham discussions of 2020, they were on the same side of a wall that had been built to keep 2 children safe. At 9:12 inches the morning, the Kensington Palace feed released a video. The setting was a playroom in the Wales family home, natural light coming through a wide window, children's drawings pinned to the wall behind the frame, a bookshelf visible on the right side of the shot. Catherine sat in a plain chair, wearing no jewelry beyond her wedding ring, and spoke for 90 seconds without a script. "Children deserve routines," she said, laughter, and the certainty that parents will always walk back through the door. Wherever duty calls us, we must never let ambition eclipse that promise. 2 million views before the hour ended, 50 million by nightfall. The data firm Blue Pulse tracked the sentiment accumulation across the day, 78% positive in the first 6 hours, crossing 80% by the following morning. Analysts credited 3 specific production choices: the plain setting, which communicated the absence of staging, the children's drawings in frame, which communicated the specific domestic reality the statement was about, and the decision to use no legal language whatsoever, to not mention any court proceeding or any institution or any name other than the implicit ones that everyone watching already knew. The video did not make an argument. It made a statement of values and allowed the audience to apply those values to the situation they were already thinking about. Prime ministers in Australia, Canada, and New Zealand referenced the clip within 48 hours when asked about protections for dual national minors, not by citing it as evidence in any legal sense, but in the way that political figures reference cultural moments that have crystallized a public mood they need to speak to. The clip had done something that no palace press release and no legal filing and no carefully worded institutional statement had been able to do in the weeks of escalating crisis. It had moved the conversation from the specific and complicated to the universal and simple. Whatever one thought about the Sussex marriage, the Sussex finances, the Sussex departure from royal duties, or the Sussex brand, the 90 seconds of Catherine in a playroom were about something that the vast majority of people watching had a direct relationship with. Children deserve routines, laughter, and the certainty that parents will always walk back through the door. That sentence was not a legal argument. It was a statement of the thing that everyone watching already believed and needed to hear someone in the palace say plainly. Commentators in Barbados contrasted Catherine's appeal with what they characterized as the perceived opportunism of the Doha plan. The palace reinforced the narrative through low-profile charitable contributions and treaty briefings to high commissions across the Commonwealth. At a mental health reception that evening, William was asked about the week's events and offered a metaphor that was immediately linked to the Doha crisis by every journalist present. Guardrails, he said, are not cages. They are white lines that keep families from swerving into oncoming traffic. The room understood. The notice of intent to wind up Archwell Foundation reached the California Attorney General's Registry of Charities within days of the ruling. The submission triggered an automatic 90-day freeze on all outgoing payments and opened the foundation's accounts to a joint investigative team from the UK Charity Commission and the United States Office of Tax Exempt. Organization review. 47 questionable transfers came under immediate examination, most routed through Sand Pillar Media or Echelon Limited. The central question the investigators were pursuing: had any donor funds been diverted to finance airfare, villa deposits, or tuition drafts connected to Project Mirror? The answer to that question would determine not only the scale of financial restitution required, but whether civil penalties might escalate into something more serious. The IRS had issued a soft letter requesting explanation of $238,000 in consulting fees, coded as international student outreach. If misrepresentation was established, civil penalties in the seven-figure range were possible before the year closed. Meghan's new legal counsel, Harold Sykes of Sykes and Linkous, had mapped 3 survival tracks. The narrowest was a procedural appeal against Judge Caldwell's $5 million relocation bond, arguing it constituted excessive prior restraint on future international travel. The more ambitious was a petition to modify the 10-year commercial word ban on the grounds that it interfered with her ability to monetize a personal trademark she had established before any of the current proceedings. The most speculative and the one most discussed in whispers rather than formal filings was an approach to Qatar's Ministry of the Interior for an advisor's residency permit on humanitarian grounds. A gambit that risked instant diplomatic backlash given the children's existing treaty protection status. Every route was complicated by the same underlying problem. The frozen trademark royalties that had previously covered security costs, staff salaries, and private tuition for the children were no longer accessible. Without that income flow, Meghan was operating on advances already drawn against a stalled streaming development deal and a partially paid book contract whose publisher had put the manuscript on hold, pending legal resolution. Grey Horse Strategies, the crisis communications firm she had engaged, proposed a hybrid approach: issue a concise public apology, repay half the court-ordered sum immediately, and offer a royalty stream from a future memoir to cover the balance. Auditors raised an immediate objection. Pledging proceeds from an unwritten book qualifies as a speculative asset and provides no enforceable guarantee to the court. Netflix had already notified agents that it would not resume Sussex development meetings until regulatory clarity was achieved. The silence from every major commercial partner was the loudest available statement of where the industry stood. Harry had been photographed twice in the days following the ruling. Both times, he was escorting court-appointed welfare minders to supervised video calls with Archie and Lilibet. The friends who had access to him during this period used the same 2 words independently of one another when asked how he seemed: dead, sober, and politely shattered. He was reviewing spreadsheets supplied by royal accountants, learning for the first time the full scope of how Archwell's financial records had been structured, how many line items had carried his electronic initials, what those line items had actually funded, and what the distance was between the stated purposes of the foundation and its documented activities. He accepted, without apparent resistance, that his path to any kind of public reset depended on total cooperation with every investigative process that had been initiated. He had already provided 28 sworn clarifications on Archwell expenditure codes. Princess Anne's Custodial Advisory Committee had drafted a mediation protocol in 3 steps. First, Meghan must acknowledge in writing that any future residence for the children outside their current jurisdictions requires joint parental consent plus compliance with the Windsor, California Accord. Second, she must produce evidence of stable, continuous schooling plans within current jurisdictions before supervised travel to Britain can be permitted to resume. Third, optional, encouraged, not mandated, an invitation to participate in a restorative justice process before an independent child rights facilitator. Palace aides noted that Harry had quietly communicated his support for the framework on the basis that it offered the best available mechanism for de-weaponizing the children's passports over time. His daily operating principle, as described by a friend who was in regular contact during this period, had been reduced to a single rule. If an action cannot demonstrably improve the children's stability by nightfall, defer it. It was a discipline born of the specific kind of clarity that comes from having reached the point of catastrophe and survived it. He had made his choice. He had called his brother. He had renounced a title in a courthouse. He had submitted 28 sworn clarifications. He was not performing recovery. He was executing it. The children's passports rested in a climate-controlled safe in the clerk's wing of the Santa Barbara family court. The judge's seal glinted under fluorescent light. The safe was locked. The chain of custody was documented. The documents inside would not move without a court order from a judge whose identity and jurisdiction were specified in the seal itself. Paper, in this story, had outlasted impulse, had proven more durable and more consequential than the urgency of a plan that had been moving fast and that had, in the final accounting, moved slightly slower than the legal architecture assembled to stop it. By the last days of February, the tone inside every camp had shifted from adrenaline to attrition in the specific way that institutional confrontations shift once the decisive moments have passed, and what remains is the long, unglamorous work of enforcement and compliance and recovery. The decisions that would determine the story's next phase were not going to be made in departure halls or in coded messages to charter companies, or in the kind of dramatic courtroom exchanges that produce viral screenshots. They were going to be made at filing desks and audit sessions and compliance check-ins and the kind of mediation meetings that happen in rooms with no cameras and take months to produce anything that the outside world can observe. The battlefield had moved from the spectacular to the procedural. And in the procedural version of this story, the palace held a structural advantage that no amount of charisma or narrative management or crisis communications expertise could offset. It had been building institutions for 1,000 years. It understood how to use them. It was patient in the specific way of an organization that has outlasted every other kind of crisis and understands, at a level below strategy, that the institutions survive by continuing to function even when the people inside them are in chaos. The Commonwealth governments that had responded to Catherine's 90-second playroom video were drafting legislation. Canberra was adding exit clearance requirements for dual national minors. Ottawa was reviewing its extradition instruments with Gulf states. Even private aviation companies were recalibrating their booking policies for clients with contested custodial arrangements in multiple jurisdictions. The institutional consequences of Project Mirror were radiating outward in ways that its architects had not anticipated and could not now contain. A palace aide asked for his assessment of where things stood, offered a formulation that was characteristically spare and characteristically accurate. Meghan could, he said, still regain partial public goodwill. The pathway was not closed and had not been permanently sealed by anything the court had ruled or the palace had filed. It required transparent compliance with the court's orders, genuine financial restitution paid on a schedule that the court could verify, and a pivot toward educational philanthropy conducted entirely within the current jurisdictions that the children's passports were now legally constrained to. It was not a glamorous path. It did not involve a streaming deal or a global book tour or a charitable initiative with a recognizable name that could generate the kind of media attention that the Sussex brand had been built on. It involved showing up repeatedly and without fanfare to audit sessions and mediation appointments and compliance check-ins, and doing that consistently over a period of months until the documented record of consistent cooperation became the story that the press covered, instead of the documented record of what had been attempted in January. People, the aide observed, forgive mothers who learn in public. The forgiveness is not fast and it does not come with a press cycle. But it is available to people who earn it through sustained compliance rather than through strategic communication. For Harry, the calculation was different, and in some ways harder, because what he had done was unambiguously correct and unambiguously costly in ways that correct things sometimes are when they require sacrificing something you value in order to protect something you value more. He had saved his children by initiating a legal and financial assault on their mother. He had called the brother he had spent years publicly criticizing and asked for institutional help. He had renounced a title in a courthouse and submitted to 28 sworn audit sessions. He had done all of this correctly, by every available measure, and he was living with the specific weight of having done it correctly, with the knowledge that the right thing and the easy thing were not the same thing and had not been the same thing for a very long time, and that the children whose stability he had fought to protect would one day be old enough to understand the full story of what had been done in their names and by whom he had given them a more stable present. What they would make of the complicated past that produced it was a question he could not answer. Paper outlasts impulse. Duty outlasts drama. And the two young Windsors sleeping in beds whose addresses everyone now knew were, for this night at least, where they were supposed to be.